Coming up on the bar brief, an accused newborn killer is denied bond in her very first court appearance.
DeMaggio?
DeMaggio, yes.
All right. Ms. DeMaggio, you may come up to the podium. Your attorney's present by Zoom, so he is here. I have Mr. Urbanek for the state. And I know we were originally set for an arraignment, but we now have a first appearance. Is that your understanding, gentlemen?
Yes.
Yes, Your Honor.
All right.
Meet 20-year-old Ann Mae DeMaggio, a Palm Coast student who found herself in a Flagler County courtroom facing the ultimate nightmare. What started as a report of a quote-unquote unexpected home birth quickly spiraled into a high-stakes capital murder case. Prosecutors allege that DeMaggio gave birth in a toilet and then intentionally watched her newborn baby drown. As the judge reads the upgraded indictment, we see the moment that the legal strategy for the defense shifts from damage control to a fight for survival.
And so I have reviewed the indictment. I do find probable cause as to all three charges. Those charges I've got, the first is first-degree murder, aggravated child abuse, and refuse to provide relevant information for a death investigation. That does not sound correct. Hold on a second. And the jail does a nice job of preparing these first appearance forms for us, but they may have been using old information. So I have, I did find probable causes to count 1 first-degree murder, count 2 aggravated child abuse, and count 3 is failure to report death of a person with intent to conceal the death or alter the evidence or circumstances surrounding such death. I did review the indictment yesterday, and bond on there is no bond on count 1. On count 2,
now, hold on.
$25,000.
The judge just dropped the hammer with first-degree murder. In Florida, under statute 782.04, that is the most serious charge on the books. Notice how the judge corrects the jail's forms? That's because DeMaggio was originally arrested for aggravated manslaughter. But after a grand jury review, the state upgraded it to premeditated murder. Why? Because investigators allegedly found something chilling on her phone. Images of Casey Anthony and searches about newborn premature babies and how to decrease fertility.
Let me see if I have
that
Michelle
digital
here
trail transformed a tragic quote-unquote
Michelle,
accident
I know we had some
into a case of alleged premeditation. And in Florida, a first-degree murder charge usually triggers an automatic
yes,
no
ma'am,
bond status
21st.
because the stakes are quite literally life and death.
To also arrange on count 2, it's $25,000, and on count 3, it was $5,000. And Mr. Politis, I can, if you'd like, today I can either arraign her on those new charges, or we can set that court date out.
Judge, in the abundance of caution, we do have hearing time before Your Honor and some other motions. I'd like to see if we can piggyback both the arraignment as well as my motion to reinstate the original bond, and maybe we can do all that at that hearing time that we already have set.
Let me see if I have Michelle here on Zoom. Michelle, I know we had some hearing time set aside. I think it was at the end of this month.
Yes, ma'am, on April 21st.
All right. So do we have enough time to also arraign and handle any other additional issues we may need to?
Yes, ma'am.
We'll do that then. All right, so we're just handling the first appearance this morning.
Yes, ma'am, I'll mark the calendar. Thank you.
And Miss DeMaggio, is that the correct pronunciation?
DeMaggio.
DeMaggio. Hold on. And it usually takes me about 3 times to get it right. So about the 3rd time I see you, I should be getting it. All right, thank you very much. Is that anything else, gentlemen, I can do this morning for you?
No, Your Honor.
Not from the state judge.
All right. Ma'am, thank you very much.
Your Honor, that's all my business before the court. May I be excused?
Yes, sir.
Have a good rest of your day, Your Honor.
You as well. Mr.
Thank you,
Urbanek,
Judge.
you have any further business, or are you good to go?
No, Judge, may I be excused as well.
You may, thank you.
Thank you.
Who else do we have? Come on up.
Good morning.
Good morning.
Matt Thompson here on behalf of Stephen Horton. Hoping that we could approach briefly.
You certainly can. Oh, Mr. Horton. You might have put yourself in a pretty tight spot. Case number 25 CF 880. Allegations are you violated the terms of the agreement. And I'm gonna set this at the same time as your new charge. And the new charge, I think it's April 28th for arraignment. All right, April 21st. All right, so we'll set you for that date. You've got the new charges pending as well. It's actually fortunate in a way that you entered a plea to that lower charge. Otherwise, you would have some tremendous exposure. I would very respectfully suggest that you work with your attorney to see if we can come up with something. And include the new charges as well.
Did you hear that? The defense attorney, Michael Politis, is asking to, quote unquote, piggyback a motion to reinstate her original bond. This is high stakes lawyering. Before the murder indictment, Demigillo likely had a bond set on those lower charges. But now that it's been upgraded to a capital offense, Politis is trying to fight the so-called no bond hold. Under Florida law, specifically the so-called Arthur principle, a judge can only deny bond if the, and I'm quoting, proof is evident and the presumption is great. The defense is clearly signaling their strategy here. They've already mentioned postpartum psychosis and depression as a defense. They want to shift the narrative from a cold-blooded killer to a woman in a severe mental health crisis. But with those Casey Anthony images looming over the case, that is going to be a mountain-sized hurdle to clear in front of a jury.
Obviously, you're not going to get the benefit of that prior 30 months, but if you work with your attorney in the state, you may come up with something that's not. Just listen to your attorney's good advice. You may not like what he has to say, but you're in a tight spot.
Judge, has regional conflict counsel been appointed on the new case?
No, Michelle, can you tell on Mr. Horton's new case if, let me look. I'll be able to pull it up faster, probably, Michelle.
I know that the public defender's office withdrew. I don't
So
know
we
if you
don't
signed the
know.
order yet.
Okay. Yeah, I don't see it here, but we'll get moving on it pretty quickly and then we should have an idea of what to do.
And you did, I apologize. Looks like you signed it yesterday. And that's in
Quicker than I thought.
2026. Yeah, 241.
Okay.
And Judge Angela Burke, I have her card up here. Is this the person I need to reach out to on the new law violation? Okay, all right, I will do that and we'll see what we can get done before the next court hearing.
Good plan.
Thank you, Judge.
Thank you. Thank you, Mr. Horton.
We can find out.
He just takes some notes. All right, anyone else ready to go? Miss McNichol?
Judge, I have Christopher Barbarella.
26 CF 108, and he actually has a separate case 2026 CF 91.
All right, what are we doing for Mr. Bagarella? Good morning, sir.
Good morning, Your Honor.
For the purposes of arraignment, I would just enter a not guilty plea and ask for him to be set on for pretrial. His bond in the case that ends with 91 was revoked while he was in Broward County. He wanted to see about getting that reinstated. Obviously, I haven't filed that motion yet. He just got transferred this morning and there are notice requirements.
Yeah, the state is required to have, so.
As of April 2026, Ann Mae DeMagillo remains in custody at the Flagler County Jail with no bond set for the first-degree murder charge. Her defense attorney, Michael Politis, has stated that he believes that she suffers from so-called severe postpartum psychosis, which will likely be the cornerstone of her defense as the case moves towards trial. The next major hearing is scheduled for April 21st, 2026, where the court will officially address the motion to reinstate bond and the formal arraignment. If convicted of premeditated murder, the 20-year-old faces a mandatory sentence of life in prison without the possibility of parole.